Your Honor, I know one of
Yes, ma'am.
Your Honor, I know one of my witnesses.
Host would like to. Hear me, Nicholas? What? Said the host would like to unmute you. Or something, I don't know, if this guy just disappeared.
They muted you on their end, so.
Mr. Marion, can you hear me?
Yeah.
Mr. Marion, can you hear me?
Yes, I can.
Okay, I'm gonna put you in a private meeting room. Okay, on the record again, and Coco Bizamani. Sir, what's your name?
Ibrahim.
You have just one name?
Ibrahim Haitula.
Please spell it.
Ibrahim Ibrahim, and the last name Haitula, Mahitula.
Raise your right hand. You solemnly swear or affirm to interpret in the matter before the court completely and accurately and not divulge confidential communication, so help you God. Okay, today was the date set for final pretrial.
Just to repeat that back again. Oh, I thought that was a kind of thing. The other one.
Excuse me?
I started to do to Anita.
Anita.
Yeah, he might have been booked for the victim, Your Honor.
Oh, okay. Makes sense. You can have a seat, sir. She thought you was his interpreter. Okay, we'll move to the next one until they find an interpreter. Let's see, I have some people online. Theodore Gomez.
I believe Mr. Raleigh represents him.
There's Mary Harris. Mrs. Monges. Gomez. And then Jolyn McAllister. I'm sorry. What's WRPHWR? Brandon Massie.
Just a dog. I think I got it. No, I don't know.
Okay. I don't know what that is.
Oh, maybe Whitney Ransom. Looks like one of the.
It might be Whitney Ransom.
I think that is just because she's at Walter Reed.
Okay, sounds good. On the record in the matter of the people of the state of Michigan versus Mary Jean Harris, 19-03855. Council appearance.
Morning, Your Honor. Case Markarian appearing on behalf of the people.
Good morning, Your Honor. Melanie will be warranted for Miss Harris, who's appearing by Zoom.
Ms. Harris, are you there?
Yes, I am.
Okay, today's the date and the time that was scheduled for a hearing. We have a report from the State of Michigan Department of Health and Human Services Center for Forensic Psychiatry dated October 1st, 2021. Council, did you both get a copy of the report?
Yes, Your Honor.
Yes.
Okay, the body and the conclusion or the opinion of the evaluator was that it was the opinion that Ms. Harris was competent to stand trial at the time of the evaluation. Any reason to make objections to the body or the conclusion of the opinion?
I'm from the people.
I leave it to the discretion of the court, Your Honor.
The court will adopt the report, incorporate the findings into the court record. An order of competency will be entered and Ms. Harris will be set for a next court date. She's being charged again with weapons carrying concealed. So the matter will be set for a new preliminary examination date. Do you believe that we need another probable cause conference?
Yes, Your Honor.
31st. October 31st at 9 for probable cause conference.
And then December 5th and 9 for the exams.
December 5th at 9 a.m. for the preliminary examination.
Thank you, Your Honor.
Ms. Harris, no problem. Ms. Harris, do you have any questions?
No, I don't.
You must appear in person for your preliminary examination. Any additional matters for the record today, counsel?
Nothing from the people.
Nothing for the defense, Your Honor.
You're all set, ma'am.
Thank you.
Thank you.
You're welcome. Counsel, which matter are you here for? Yes.
Andrew Bolt,
It's in an email yesterday, Your Honor, not realizing that the court was actually closed, but it's gonna be an adjournment request.
It's on the record in the matter of the people of the state of Michigan versus Andrew David Bowler, 24-02785. Counsel appearance.
Good morning, Your Honor. Case Mark Arian appearing on behalf of the people.
Stuart R. Schaefer, SHA FDR, on behalf of Mr. Bolt.
Okay, today was the date set for both a pre-trial, that is, as well as a bond violation hearing.
Yes.
There's a request for an adjournment.
Yes, sir.
Yes.
For how much time? This is your request.
Yes.
At 10:30.
October 29th at 10:30 work for you. At 10:30.
Yes.
Okay, October 29th at 10:30. Additional matters for today's record.
Nothing from the people.
Thank you very much.
Thank you.
Case dismissed.
And Mr. Palmer was here for Ransom.
Yes.
On the record in the matter of the people of the state of Michigan versus Whitney Lynn Ransom. Although I don't see her there.
And actually, Judge, I haven't had an opportunity to speak with her yet because
Is Whitney Ransom present?
that was.
Oh, okay. Absolutely.
Yes.
Ms. Ransom, I'm gonna put you in a meeting room with your attorney, okay?
Okay.
Okay, Mr. Riley is here. On the record in the matter of the people of the state of Michigan versus Brandon Massie, 24-02779.
Your Honor, Case Mark Arian appearing on behalf of the people.
Jacob Riley on behalf of Mr. Massie.
Mr. Massie is present via Zoom. Mr. Massie, please start your video.
Okay. I'm here.
Why are there no lights on? Okay, thank you. Today was the date and time set for pretrial for one count of domestic violence. How are we proceeding on this?
Your Honor, we'd be requesting that this matter be set for final pretrial and trial dates.
There was no offer.
There was an offer, Your Honor. It was to plead guilty as charged with 76948 status.
November 5th at 8 a.m. And then jury trial. January 6th at 8 a.m.
Final pretrial, November 5th, 8 o'clock in the morning in person at the court. Jury trial is scheduled January 6th, 8 a.m. also in person at the court. Do you have any questions today, Mr. Massie?
No.
Found in this matter will continue as well as the no contact order. Any additional matters for the record, counsel?
Nothing further from the people.
I know, Your Honor.
You're all set, Mr. Massey.
Okay, thank you.
You're welcome. On the record, in the matter of the people of the state of Michigan versus Theodore Perez Gomez, 24-02266, appearance, please.
Morning, Your Honor. Case number appearing on behalf of the people.
Jacob Riley on behalf of Mr. Gomez.
Mr. Gomez is present via Zoom. Today was the date set for a operating while intoxicated pretrial. Counsel, how we proceed?
We have received a plea offer. My client is considering that offer. We asked that this be set for a final plea trial. Of course, by that time, we will have made a decision.
What's the offer?
Yes, Your Honor. The offer was to plea as charged to avoid having this reissued as a high BAC and reckless driving. That offer will only stay open until the date of the final pretrial. If we do not hear back with an acceptance by then, that offer will expire.
November 5th. Final pre-trial, November 8th, 8 o'clock in the morning, in person at the court. Jury trial is going to be scheduled for January 6th, 8 o'clock in the morning, also in person at the court. Do you have any questions today, sir? Mr.
No,
Gomez,
no, Your
okay.
Honor. No, Your Honor.
Okay.
I hear you loud and clear.
Okay, very good. We'll see you in person on November 5th at 8 a.m., okay?
So
Your
I have to be
I'm
there?
sorry?
I have to
You have
be
to
there.
appear, yes, you must appear in person.
Okay, thank you.
No problem. And your offer will expire on that date as well, okay?
All right, thank you.
You're welcome. Any additional matters for the record, counsel?
People.
No, Your Honor.
You're all set, Mr. Gomez.
All right, thank you. You have a good day, Your Honor. Thank you.
Same to you. On the record in the matter of the people of the state of Michigan versus Jolyn McAllister, 24-02325, appearance, please.
Morning, Your Honor. Case number appearing on behalf of the people.
Jacob Riley on behalf of Ms. McAllister.
It was the date set for pretrial for Docket large. How are we proceeding?
Your Honor, at this time, I have received proof of measures to fix the dog at large issue and be in compliance with the statute. People would move to dismiss at this time.
Motion to dismiss is granted. You're all set, Ms. McAllister.
Thank you.
You're welcome. Mr. Gomez, you're free to go.
Thank you.
You're welcome. Who's on the iPhone? Won't let me bring Mr. Marion back, and I can't close the breakout room right now.
Your Honor, I have not been able to speak with him. When I went into the breakout room, he was muted again.
It'll be a dismissal, Your Honor. There was a global resolution yesterday on the circuit court.
Okay, for Marion.
Yes.
Okay, you want to, okay, on the record in the matter of the people of the state of Michigan versus Alexander Marion in files 24-01408 and 24-02539, council appearances.
Morning, Your Honor. Case mark appearing on behalf of the people.
Jacob Riley on behalf of Mr. Marion.
It was the date set for pre-trials on both matters, and I do see that we did adjourn at least one for global resolution. How we proceed?
Yes, Your Honor. Per APA Randall Berman and Andrea McCray, Judge Aquilina's docket of prosecutors, there was a global resolution reached, including both these cases and the felony cases for Mr. Marion yesterday. Specifically, the circuit court case numbers are 24-382FH and 24-339FH. I think there might be some zeros missing there, but there was a global resolution reached in those two cases in the circuit court, so the people moved to dismiss these two cases today.
to misdemeanors, no objection. Okay, these files will be dismissed. You're all set, Mr. Marion. Who's on the iPhone? Not by the interpreter's press. Can you unmute your device, please?
I was here for the case of Ali Giat. I'm not sure if he's still here.
Okay, why are you in the Zoom courtroom for it?
Because I was a part of the team.
You were subpoenaed to appear via Zoom?
No, I called the courts and they gave me this.
Okay, that was inaccurate information. You can appear, or if you're just looking to watch the proceeding, you can view that via YouTube. Only litigants and witnesses subpoenaed to appear via Zoom can be in the virtual courtroom, okay?
Oh, okay.
But we are live streaming, and he should be brought up shortly, I believe. Let me see here. Let me remove Marion. Mr. Farmer, are you ready on Ms. Ransom?
Yes, Your Honor, I am.
On the record in the matter of the people of the state of Michigan versus Whitney Lynn Ransom 24-01198, counsel appearance.
Morning, Your Honor. Case Mark Herring appearing on behalf of the people.
And good morning, Your Honor. Robert Palmer of the Public Defender's Office on behalf of Ms. Ransom, who appears today from Walter Luther Hospital.
Okay, today was a date set for hearing for competency. The court does have a report here from the Center for Forensic Psychiatry. And it was dated, prepared October 7th, 2024. Did you both get a copy of this?
Yes, Your Honor. Yes, Your Honor.
Okay, the opinion of the examiner was that Ms. Ransom is competent to stand trial. Any reason to make objections to that report?
No, Your Honor, not from the people. I do not have any basis to make an objection, Your Honor. I would say that in meeting with Ms. Ransom this morning, she is a significantly different person than the individual I dealt with prior to this referral. She absolutely seems to be restored. I would ask that the matter be set on PCC.
Okay, the court will adopt the report and incorporate it into the record. Order of competency will be entered. This matter will be set for probable cause conference and preliminary examination.
October 31st, 9:30 for the PCC.
Probable cause conference will be October 31st at 9:30 in the morning.
And then we can do exam December 6th. And
December 6th at 9:30 in person for preliminary examination. Do you have any questions for the court, Ms. Ransom?
No, Your Honor.
I'm sorry, you said November 6th?
No, I said October 31st and then December 6th.
Oh, December 6th.
Yes,
What time was that at?
9:30 for both.
Got it. Thank you.
No problem. Any additional matters for today's record?
Nothing from the people.
I have nothing, Your Honor. Well, I guess the only thing I would ask is, I think that now that we stipulate to the report, she'll automatically be transported from the hospital back to the jail. I'm not entirely sure how that works.
She likely will be. I just saw where she was remanded because of court for the exam. She failed to appear. Is that what
She
happened?
did, yeah, Your Honor. She failed to appear, and then she had showed up on Zoom the morning of the preliminary examination. The court ordered her to be here, and then she
I remember that.
didn't make it in time. So she was remanded based on that. I do anticipate that, I guess I'll give the prosecutor a heads up as well. I do anticipate that probably at the probable cause date on October 31st, we'll make a bond argument, but we'll see where we're at that time. I'm not making that argument today.
Okay, sounds good. So we'll continue to October 31st at this time. Any additional matters for the record?
Nothing from the people, nothing from the defense, Judge. Thank you.
You're all set, Ms. Ransom.
Thank you. Your
You're
Honor.
welcome.
So, again, register the jurors this morning. He was only put on there for his probation violation, which is at 1:30, so he will not be here this morning.
Oh, well, we're running trial, we're not even doing violations this afternoon, so there's that. So it looks like Giat will not be here. Let's see what's not on the jail list for this morning. I don't know what happened to my court officer or.
She's trying to straighten out a series of interpreter problems.
That's what I was understanding, or that's what I was about to ask about, what happened to them.
Yeah, there's a few people arguing with her.
He's one of these is a court content.
Oh, we did McAllister. And we just did Marion, okay. On the record in the matter of the people of the state of Michigan versus Kevin McKenna, 24-01386.
Good morning, Your Honor. Case Mark Herring appearing on behalf of the people.
Jacob Rowley on behalf of Mr. McKenna.
Mr. McKenna is scheduled for sentencing today. He was before the court on a misdemeanor operating while intoxicated. I have a report prepared for pre-sentence October 7th, 2024. Counsel, did you get a copy?
Yes, Your Honor.
You need to make corrections, updates, or deletions.
We have none.
You should please.
Your Honor, I believe the assessment and recommendations of the report are fair and appropriate. I would ask that the court broadly follow the recommendations of the report. We have Mr. McKenna, I would say certainly he understands the seriousness. Done a lot worse than it did. He knows that this is not something that can continue. He's determined to get sober and certainly to not drive while intoxicated again. I would simply ask that the court sentence to a term of probation. I think he would benefit from some counseling and supervision, but I think he is committed to sobriety going forward.
Quiet one with the statement.
No, Your Honor.
Okay, I reviewed the pre-sentence report and the recommendation. This is a conviction after an incident that involved a blood alcohol content of 0.329 or higher. And I recognize that you gave some indication to our probation department that your belief is that your blood alcohol content was so high because of medication you were on. Were you on some alcoholic medication?
No, it's an anti-seizure medication that affects my liver and the ability to break down alcohol like a normal person.
Oh, okay, so you were aware that that medication could have an impact on your body when you consume the alcohol? Okay. The report opines that there was no indication of random responding and a high probability of a substance use disorder. You overall scored a moderate high needs and personality and attitude domains, moderate low need and substance use domain, and then low needs in other domains. It said you were only employed part-time. That's still accurate?
Yes, ma'am.
Okay. The recommendation is for 12-month probation with the suspension of 14 days jail credit if successful. The court finds the recommendation to be appropriate. You will be sentenced to a term of 12 months probation. While on probation, you're not to use, purchase, or possess any alcohol, marijuana, or controlled substance unless you have a valid prescription. You will be required to submit to random preliminary breath testing and urinalysis testing. You're responsible for the fee for that, okay? You're not to be at any bars or any nightclubs. You're not to engage in any assaultive or threatening behavior. You're not to purchase or possess a firearm, ammunition, or weapon of any kind while on probation. Do you understand that?
Yes, Your Honor.
You to maintain your employment and provide evidence of that to probation. I'm gonna order that you complete an outpatient substance abuse program as well as attend regular 12-step meetings and provide verification of that as directed by probation, okay?
Yes, Your Honor.
There's a $30 per month oversight fee that you're responsible for while on probation. $75 crime victim rights fee that will be assessed plus a $50 state minimum cost that will be assessed. I don't see anything listed here for OWI cost recovery.
There you are.
There will not be an assessment of OWI cost recovery. Can you provide that to the defendant, please, Yolanda? Oversight fees will amount to $360 for a year of oversight fees. I'll waive discretionary fines and costs. Total is $485. You'll make monthly payments on that. You were just provided the advice of rights as to probation. You should review that. It advises you of your rights as it relates to probation. You have the right to request early discharge after you have completed half the original term ordered by the court, so long as you've not had any violations within the 90 days preceding that request. You would make your request by using the MC 512 form, which is located on the court website. You would file a copy of that request on the probation department as well as the prosecutor's office. The prosecutor's office is 14 days from receipt of your notice to respond in writing with any objections to your early discharge. If I set it for hearing, you have the right to hire an attorney to represent you for that hearing. You would not have the right to have court-appointed counsel for any hearing for early discharge. Do you have any questions about those rights? You would sign at the bottom there and return that to my court officer. On your way out, I want you to check in with probation so they can make sure they have accurate information for you, okay?
Yes, sir.
And these are matters for today's record.
That's a good defense, Your Honor.
Thank you, you're all set. Record in the matter of the people of the state of Michigan versus Jalen Rutledge, 24-02105.
Your Honor, case not hearing on behalf of the people.
Assuming that his attorney is Ms. Sutter. Is that correct? You know who your attorney is, sir? Ms. Sutter, okay, you can have a seat. Oh, Ms. Sutter, that this is your client. Oh, okay. Appearance for the record.
Morning, Your Honor.
If I may very quickly before we do that, I believe this is a protected hearing. Yes, it's a high cut status.
That's
He's not been sentenced yet. I have not granted it.
Just want to make sure, Your Honor, because on the docket, it's that's not double.
Grant first.
on this case, Mark, Sharon, on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. Rutledge, who is standing to my right.
Oh, today's the date, the time that's set for sentencing. I do have a pre-sentence report recommendation. It was prepared on October 9th of 2024. Did you get a copy of that?
Yes, Your Honor.
Okay, any reasons to make corrections, updates, or deletions to the report?
No, Your Honor.
Okay, you can make allocution.
Thank you, Your Honor. I do believe this is a fair recommendation to be made by Mr. Sumter. I agree with his overall impression and assessment of Mr. Rutledge. He has someone who, in conversation with me as well as Mr. Sumter, kind of stepped up and said, I messed up here. I made a series of decisions that were not good for me or anyone else around me at the time. And he's now doing what he can to improve himself, his situation, and the people around him, so he does not see himself in this kind of place again. To that end, what he's done since the time of this incident is gained full-time employment. As the report indicates, he is now working full-time at the Amazon warehouse in Lansing. He's now in his first week post-orientation there, and he advised me that that's going quite well, and he's quite happy and excited about it. He's trying to do what he can here to put himself on a better path in life. As the court's well aware, he's young, and he's trying to figure himself out. And I think he's making good steps to doing that. And I believe what Mr. Sumter is recommending here, primarily the moral recognition therapy, is another good step along that path. It helps people kind of reprocess the way they think in moments of stress, anxiety, frustration, fear, anger. And I think all of that was a little bit at play here. So the moral recognition therapy is, I think, an ideal next step for him. The only, I suppose, modification I would ask the court to consider is the random PBT or analysis testing. I'd ask the court to consider it for a temporary period of time. I understand intoxication was at issue here in the original incident. As I've said, Mr. Rutledge is quite new in his employment, so he's not financially quite stable yet. And the random testing is, of course, an additional expense for people on top of fines and probation costs. So I'd ask the court to consider, rather than making that a requirement throughout the entire term of probation, for perhaps a short period of time at the beginning to ensure that he is remaining compliant with those orders. Thank you.
Mr. Rutledge, want to make a statement? He said no, thank you. You know, rough 2024 it looks like. Looking at your criminal history, you didn't have one before this year. And then you're 21.
I'm 19.
You're 19. So you're not even supposed to be drinking in the first place, correct? You had a blood alcohol content of 0.28. I'm happy to hear that you are making a transition toward being more responsible. You are very young. You have your full life ahead of you. And this is not how you want to close out your teenage years in courtrooms and on probations. It's not what you want to do. So hopefully you've learned from these mistakes. Completely avoidable, these interactions with the law enforcement. Completely unavoidable, avoidable, and you didn't have to be here. So that's about you and how you control yourself when you're on the outside. You're working now. You're making really good money for someone who's at your age right now. Where do you live? You live at home? With your parents?
Yeah.
Oh, well then, you make that kind of money. I don't think that you dropping is a financial concern. Your concern should be that you had a blood alcohol content of 0.28 at 19 years old. That should be the concern, and making sure you address any concerns as it relates to potential underlying issues. It says here that a substance abuse assessment wasn't received because I don't believe it was ordered. So I don't know what your needs are as it relates, but it did state that you reported consuming excessive amount of alcohol to cope with stress. So that is a concern for the court. I'm going to adopt the report. It will be placed on a term of 6 months probation. I will grant HYTA status, which will make your matters private in the future, okay? You will be ordered to complete and participate in moral recognition therapy. maintain your employment. Did you finish high school?
No,
You did not? Why not?
Having trouble in school, man, I was just gonna work on getting my GED.
Okay, well, you definitely can do that, 'cause it's gonna be an order of the court that you'll be enrolled in a GED or high school diploma program, and you'll provide evidence of that to probation, okay? Here that if there's no issues with the random testing that I'm gonna order, that it could be suspended after 90 days. However, you are not to have any alcohol, marijuana, or controlled substance unless you have a valid prescription. You will be required to submit to random preliminary breath testing and your analysis testing. You have to pay the fee for that, okay? You're not to be at any bars and nightclubs. That shouldn't be an issue because you're 19. You're not to engage in any assaultive or threatening behavior. You're not to possess a firearm, ammunition, or weapon of any kind. Do you have any questions about your conditions of probation at this time? There's a $30 per month oversight fee that will be assessed per month of probation. $180. You'll report to probation via Zoom, okay? Any restitution or anything else. I'll waive discretionary fines and costs. There is, however, a $75 crime victim rights fee plus a $50 state minimum cost that you'll be responsible for. So it's $305. You'll make monthly payments on that, okay? You'll check in with probation before you leave here today to make sure the information we have for you is accurate. You'll also get notification once the judgment of sentence is prepared for you to review and sign that, okay? Up to you. And on the other matter, before I release you, I'm going to advise you that there is an advice of rights as to probation. You have the right to request early discharge from probation once you've completed half the original term ordered by the court. So long as you've not had any violations within that 90 days and that you've completed all the required programming, you can request early discharge by using the court's NC 512 form that's on the court website, or you can get it from your probation officer. You would complete that form, file a copy of it on probation, and then a copy must be filed on prosecution's office. The prosecutor has 14 days from receipt of that notice to file any objections in writing to your request for early discharge. If I set it for a hearing, you have the right to hire an attorney to represent you for that hearing. You would not have the right to have court-appointed counsel represent you for that hearing. I've never held a hearing for early discharge, but I don't know. It could happen. If it does, you can hire an attorney. Okay, do you have any questions about that? Any additional matters for the record?
No, Your Honor.
Nothing further. Thank you.
Thank you. Good luck to you, sir.
Yeah.
Who's representing Trevino?
That would be me, Your Honor.
On the record in the matter of the people of the state of Michigan versus Brent Trevino.
Your Honor, I apologize. I got his voicemail yesterday, so I haven't been able to review his PSI with him. I understand. So I would, if the board's willing, I would need a couple minutes to review his PSI with him before.
Okay, just, is anybody else waiting for you?
Not for me, Your Honor, no.
Okay.
I do. We should go to the council after, so yes.
Morning, Your Honor.
Good morning. Oh, I
Told her to
see.
say hey.
No, I see you on my docket.
Oh, well, that was just. my
Charlotte
application.
Singh.
Yeah.
What's
I
going
do
on
have
with
a case
that?
up this morning, huh?
What's going on with that?
Working
You need another date?
on it. No, hopefully. When you get it in your office.
Oh, okay. Well, so are you waiting for a court date at all?
Yes, for Scott.
Oh, this is a bond show.
Yeah, it's a show cause hearing.
I don't think he's here.
No.
Dakari Scott present.
Yeah, I talked to him. He was supposed to turn himself in, but as of this morning, I see no indication of that.
This is a different Scott. Let's see here. You have two Scotts on the record today? No, did somebody get me the wrong Scott?
You have two Scotts, Your Honor.
Okay.
Aisha Scott at 10:30 and then Dakari Scott at 9:50.
9:15.
In the plastic. Is that my email?
Real quick, Your Honor.
Wait. It is the one in the plastic. On that one. Post upon them? Or which one? The bond show cause is scheduled on the improper, it says. Yeah.
Am I at the wrong place?
You're at the right place. He did.
He had a 200 cash charity, so. I'm
Okay.
assuming he left 200
Bond is
there.
forfeited. He's already in one sets. You're all set.
All right.
Thank you.
Why is it on the docket? I guess if it's already warned in the minutes.
I don't know. Did they not forfeit the bond?
They ordered for the bail bond to.
I don't know. I don't really. No idea. Maybe they can explain that to me in the future, but I don't get it. Let's see. We don't have anybody else right here. No one's outside.
They're all here for Otis. And,
Nobody here for 9:15. Okay, let's see. 9:15. I was supposed to have. Let me give you the file because he was not put on for this morning, and all the 130s are being reset.
I reset the.
October 22nd. Reset, yeah.
She's being reset.
No, she reset yet. Here. Martinez is not here. Okay. Mitchell is not here. Short because of the pain. And then
Anderson here.
who represents Ms. Anderson? And any your client is coming?
Yes, Your Honor. Yeah, I just say it's arrival any moment, but.
Did you need to speak to Ms. Anderson?
No, Your Honor, I'm ready to go on this Anderson.
Okay, on the record of the matter of the people of the state of Michigan versus Rashana Anderson. 1-01908, and I have 16-03109. I have a prosecutor.
Yes. Yeah, this one.
Good morning, Your Honor. Joel Martinez appearing on behalf of the people of the state of Michigan.
Good morning, Your Honor. Assistant Public Defender Lawrence Sutter on behalf of Ms. Anderson, who's standing to my right.
Okay, Ms. Anderson has in the 16 file assault or assault and battery, and then in the 21 file an aggravated assault. How are we proceeding?
Your Honor, pursuant to my notes, we have offered for Ms. Anderson to a 1-for-1 offer for her to plead guilty to 1 count of ag assault, and we would dismiss the assault and battery case. It's my understanding from speaking with Ms. Sutter this morning that Ms. Anderson wishes to leave this matter set and schedule a final pretrial.
That's correct, Your Honor.
On pretrial November 5th. January 6th.
Final pretrial will be scheduled November 5th, 8 o'clock in the morning in person at the court. And then jury trial will be set for January 6th at 8 a.m. in person at the court, okay? Do you have any questions, Sam? No. Get your notice to appear. Any additional matters for the record?
Nothing additional from the people, Your Honor. Thank you.
Nothing further, Your Honor. Thank you.
Thank you.
Hi, this is Mehrunisa Ahmed. I can't hear you guys, just so you know. Okay.
on the iPhone? They started running Mr. Trino. Breakout. Decker. To Mr. Zany's matter, Mr. Fielder. Sorry. Welcome to Mr. Zany's matter. Oh, you're right.
Yes.
Yeah.
The client is out there, Mr. Zany is out there as well, and I believe Mr. Zany, my understanding is he's consulting my office
Okay, there's an
to
interpreter
to try
here.
to get a resolution, Judge.
Is that for his matter?
Yes.
Okay. Sounds good.
You have Miss Aisha Scott also.
Scott doesn't have any accommodations. Fine. Mr. Mercury and Aisha Scott is here.
Yes, Your Honor. Unrepresented.
Correct. Looks like it's a whole thing. You see the email?
On Zoom or here in person?
Ms. Scott's there. No, I was talking about the email about there's not being any heat in multiple areas of the building when it's 39
yeah, I
degrees
see it
outside.
now.
What did I tell you all? What did I tell you all last week was gonna happen?
It was
When
gonna
the
explode.
when the temperature drops.
You did say.
Give them some taking strengths.
Number 7's future review soon. Reverses visible signs of sun damage with a world-first peptide technology. Number 7, don't regret, just reverse.
Stay ahead of your moderate to severe eczema and show off clearer skin and less itch with Dupixent, the #1 prescribed biologic by dermatologists.
Are we adjourning?
Just follow up from the front office of the prosecutor's office for additional discussions. I think. Oh, 2 weeks?
So we're going
Sure.
October 29th at 10:30, October 29th at 10:30 work. Ms. Ahmad, you're all set. The matter has to be reset.
Okay, thank you.
Thank you. On that one, you should notice for your client.
What was that date again? I'm sorry. I missed it.
October 29th. 10:30.
Thank you.
Ms. Scott, are we ready on Ms. Scott's?
Your Honor, Scott's gonna be a dismissal. We received.
You're all set, ma'am. Thank you. You're welcome.
Does she need to wait for a notice or anything, Your Honor? Okay.
It's on ticket. Thank you. Okay. Um, Representative Mr. Carter, Ms. Sutter. Okay, he's on Zoom. You ready on this matter? Marcel Carter,
Yes, Your Honor, I received proof. It's gonna be a dismissal as well.
you're all set, Mr. Carter. You're free to go. Your case was dismissed.
I think you're muted, Mr. Carter. We can't hear you.
Okay, Marshall W. Marshall Weathers. Okay. Mr. Neal, are you ready with Mr. Weathers?
Good morning, Your Honor. Yes, we're all set. I did send an email to the APA this morning. Maybe Mr. Martinez is present. There was one remaining issue that I would like to address. Maybe we can address that before we go on, but the other matter has been resolved.
Mr. Neal, we're going to be including that as a part of the dismissal of the remaining balance. I saw your email.
Works. That works. Thanks.
On the record in the matter of the people of the state of Michigan versus Marshall Weathers in 24-02488 and 24L2814962, counsel appearances.
Your Honor, case Markarian appearing on behalf of the people.
Good morning, Your Honor. Rico Neal appearing on behalf of Marshall Weathers, who is present via the video system. Mr. Weathers, please state your name for the record.
Marshall Weathers.
Okay, today was the date that was set for pre-trial. Mr. Weathers, the people have provided me a plea sheet. It says that they're offering for you to plead guilty to count 2 of operating while intoxicated under MCL 257.6251. That's a misdemeanor with a maximum penalty 93 days and or $100 to $500 in fines and or 360 hours of community service. And that they will dismiss counts 1 and 3 as well as the charges in file 2 for L2814962SN. You understand the offer there?
Yes, ma'am.
And you wanted to accept this offer?
Yes, ma'am.
Please raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, ma'am.
Okay, you can put your hand down. You have the right in this matter to proceed to jury trial because you have the right to the presumption of innocence. So you have the right to require the prosecution prove your guilt at a jury trial by proving each element of the charges being brought against you beyond a reasonable doubt. You have the right to remain silent at trial and not have silence be used against you, or you can waive silence and testify at your trial if you'd like. You have the right to see, hear, or question any other witnesses the prosecution intends to call against you. You can have witnesses subpoenaed to testify for you at your trial. Represent evidence at trial that you believe show a defense to the charges being brought against you. Do you have any questions about those rights?
No, ma'am, I understand.
And you want to give those rights up today, sir? Do you want to give up those rights to plead
Yes, ma'am.
guilty to count 2? Is
Yes,
anybody
ma'am.
threatening you to do that?
No, ma'am.
Any promises being made to you in exchange for a guilty plea?
No, ma'am.
Are you currently on probation or on parole?
No, ma'am.
You understand that a guilty plea could result in a conviction that you may need to report to your job, or you may need to put this conviction on a future job application.
Yes, ma'am.
It also could have impact on travel or immigration status that you may be seeking. You understand that?
Yes, ma'am.
As to operating while intoxicated, how do you plead?
Guilty.
And you're pleading guilty because you believe you're guilty?
Sorry, could you say it one more time? My son is coughing in the background, ma'am.
No problem. Are you pleading guilty because you believe you're guilty?
Yes, ma'am.
Factual basis, counsel.
Thank you, Mr. Weathers. On or about March the 2nd, 2024, you were operating a motor vehicle on East Grand River and Clipper Street in the city of Lansing, Ingham County, state of Michigan.
Yes, sir.
East Grand River and Clipper Street is a roadway that's open to the public for cars to travel.
Yes, sir.
Prior to operating that motor vehicle, you had consumed some alcohol.
Yes, sir.
You were subsequently a traffic stop was performed upon you for either disregarding the traffic signal or no tail lights.
Yes, sir.
You came into contact with police and subsequently was arrested.
Yes, sir.
You were subsequently taken to the hospital where a blood draw was taken by you.
Yes, sir.
The results came back at a 0.171.
Yes, sir.
You'd agree with me that 0.171 is greater than 0.16
Yes, sir.
and 0.08.
Yes, sir.
You have no reason to contest the accuracy of the blood results, do you?
No, sir.
Thank you, and I believe that satisfies the factual basis.
Any questions from
People
you?
are satisfied with the factual basis. Thank you, Your Honor.
The court is satisfied with the factual basis, and I'll accept your plea. I find your plea to be made freely, voluntarily, and intelligently. This matter is scheduled for sentencing December 17th at 9 o'clock in the morning. Did he recently undergo a substance abuse assessment?
Your Honor, he has had a substance abuse assessment along with he's completed the MAD victim impact panel along with the highway safety seminar.
Okay, so he can provide copies of those to probation so that he will not have to incur the expense of a new substance abuse assessment prior to sentencing. And he can appear for sentencing via Zoom. He needs to report to probation, however, in person within the next 48 hours. You understand that, Mr. Weathers?
Yes, ma'am.
And we'll see you for your sentencing date on December 17th. Do you have any questions, sir?
Where do I go to for the probation?
I'll call you, Mr. Weathers. I'll call you.
Okay.
Any additional matters for the record, counsel?
Nothing from the people.
Nothing further, Your Honor. Thank you.
Thank you. You're all set, sir.
Thank you. Have a good day.
Thank you. Okay, on the record in the matter of the people of the state of Michigan versus Brent Trevino, 24-01701, counsel appearance.
Morning, Your Honor. Case of Markarian appearing on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Lawrence Sutter, on behalf of Mr. Trevino, who is standing to my right.
Okay, Mr. Trevino, I have here a pre-sentence report. It was prepared back on October 8th, 2024. Counsel, did you get a copy?
Your Honor, yes, I did.
Any reason to make corrections, updates, or deletions?
Yes, Your Honor. There's an update to be made in the employment section. They indicated correctly that he was switching jobs between pre-sentencing and sentencing. He has an update for that. He is now employed full-time at Barnes Aerospace, making approximately $20 an hour.
I will be updating the additional updates.
Nothing further, Your Honor. Thank you, Your Honor. This is another individual where I believe the pre-sentence report accurately and fairly reflects his willingness to take responsibility here. He acknowledges that this was a pretty stupid situation to find himself in, and he fully accepts that the fault for this lays with him, his decision making, his actions the day of. He has been in conversation with me, and it seems like in conversation with his probation assessor that he was going through a bit of a rough time and he wasn't making great decisions, and it led to why he's here today. And he wants to step up and make right and make the steps necessary so that he does not find himself in the situation again. To that end, I think the domestic violence program is a fair one here in terms of rethinking the way he deals with stressful situations, especially when dealing with loved ones whom he doesn't want to put in this kind of situations. He also doesn't find the recommendation for random alcohol and drug testing unfair or unreasonable given the assessment of the situation here. I would ask the court to consider a 9-month term of probation for him. He is just switching jobs, and I think 9 months is a satisfactory amount of time for him to get through that domestic violence program, as well as a little bit beyond it, to set himself up for success here, both for his family, for his community, for himself, and to try to show the court that he is taking this very, very seriously. He's taking all the steps necessary to improve his situation and the situation of the others involved in this case. Thank you, Your Honor.
Thank you. Did you find want to make a statement?
I do not believe he wishes to do so, Your Honor.
No. Review the pre-sentence report and the recommendation, as well as the defendant's prior criminal history, which there was only one other conviction, ironically identical in nature, and was charged as a DV, but as a disorderly jostling from 2018. And then here we are in 2024 with a similar situation. So something in your life is going to have to change. You're going to have to get some tools to help you better address conflict so that you don't engage in conduct that's disorderly. You understand that, sir?
Yes.
The recommendation was for 12 months probation with random drug and alcohol testing and some conflict resolution counseling. And they did meet the criteria for alcohol use disorder in sustained remission and the criteria for level 1 treatment because of the stability in recovery. So I don't think the need substance abuse treatment is necessary at this time. I will adopt the recommendation. I'll also amend the time frame to 9 months. While on probation, you're not to engage in any assaultive or threatening behavior. You're not to purchase or possess alcohol, marijuana, or controlled substance without a prescription. You're to submit to random preliminary breath testing and urinalysis testing. You're not to be in any bars or nightclubs. You also have to pay the fee for the testing. You understand that? I'm going to continue the no contact order because I've not received any indication otherwise as to the victim's intent or request to remove that. So, no, participate in domestic abuse counseling while on probation and maintain your employment and provide evidence of that. I'm also going to order you to complete an anger management group, okay? There's a $75 crime victim rights fee that will be assessed plus a $50 state minimum cost to be assessed. It's a $30 per month oversight fee for probation, and you're going to do 9 months. So that's a total of $270 plus the statutory costs that were assessed for a total amount of $395. You'll make monthly payments on that, okay? You review these rights, sir? Yes. Okay. So you have the right to be considered for early release from probation after you complete half the term ordered by the court, so long as you've not had any violations within the 90 days preceding that request. You would make the request using the court's MC 512 form, which is on the court website, or you can request a copy of that form from your probation officer. You will complete the form, file it with probation, and you must file a copy on the prosecutor's office. They would have 14 days to respond in writing with any objections to your early discharge. If I set it for hearing, you have the right to hire an attorney to represent you. You would not have the right to have Ms. Sutter or a public defender represent you for any hearing for early discharge. Do you have any questions about that? Again, you must have completed all of the programming that was required and had no violations before you can make that request. And you are on a probationary term for disorderly jostling, so you would be eligible to make the request for early discharge after you've done about 4.5 months, okay? You're gonna check in with probation before you leave here. Do you have any questions for the court? Any additional matters for the record, counsel?
Nothing further, Your Honor. Thank you.
You're all set. Record in the matter of the people of the state of Michigan versus Brandon Lee Decker, 24-02616. Answers, please.
Morning, Your Honor. Casey Markarian appearing on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Warren Sutter appearing on behalf of Mr. Decker, who is joining us via Zoom.
Okay, Mr. Decker has 2 files here. One is for animal abandonment and cruelty and a crime report violation. How are we proceeding on this?
Your Honor, I think we'll be requesting, I think the request will be for a final pretrial on the domestic violence case, and maybe a reset pretrial on the abandonment cruelty case. Did receive an email from Ms. Sutter stating that the Ingham County Animal Control has seized and put down the dog, but we just need proof of that. And there was apparently a letter that Mr. Decker is going to work on.
That's right.
Abandoned cruelty, October 29th at 10.
We can do it all in the same day as a final pretrial. November 12th at 8 a.m. for both the final pretrial and the reset pretrial for the animal abandonment cruelty.
Jury trial, January 6th.
And jury trial on the domestic violence file will be January 6th, 8 a.m. You need to appear in court for all of those dates, okay, sir?
Yes, ma'am.
You have any questions?
Nope. Nope. So you said November 12th and January 6th?
That's correct.
All right. Yes, ma'am.
Okay, you're all set. Thank you.
All right. Thank you. Have a good day.
Same to you. Have we seen Edward Cade?
I can go call the hallway, Your Honor. If you'd like.
Thank you.
Edward Cade. Nope.
Thank you. Massie Antonio Heredia.
I have not, Your Honor.
I did receive an email last week, Your Honor, as I'm sure you did too, but he was temporarily released to go visit a funeral. I'm not sure if they put him back in custody or if he just got released permanently or
He
what.
failed to return. That's right. That's I don't have his files. He failed to return, so I think he revoked his file. So Orban is not here. Oh, she is here.
Yes.
Miss Orban. You, the person I saw in Meyer last week while I was trying to get my grades. And you wanted to talk about your case while I'm checking out on the self-checkout. Yeah. As I said, ma'am, I know you think I know what you're talking about, but call your attorney.
Yeah, she did speak with me yesterday, told me that I advised her, maybe okay to nod hello, but that's.
I mean, I recognize her, but I know people from everywhere, so I didn't know what I would knew her from. And she smiled at me. I thought she was just being nice. I had earbuds in my ear. I was having a conversation and she's talking. And then I said, I'm sorry, what? And she's just going on about her case. Like, ma'am, I know you think I know what you're talking about, but I don't, and you probably should call your attorney. Very good. Okay, so what I did remember is she needed some more time.
That's
because
correct,
something
Your
about a
Honor.
birth certificate.
That's correct, Your Honor. She's working on getting her driver's license. She needs a birth certificate in order to do that. She has ordered the birth certificate. Mr. Wally assisted her in doing that on September 3rd. She's got an estimated date of when it could arrive. She sent me documents for that last night. The earliest, looks like anticipated date that they might get a tour is November 9th. We would ask the court respectfully to consider an additional adjournment so she can try to get this paperwork to the Secretary of State.
Yes, November 12th at 10. November 12th at 10 a.m. Do you have any questions for the court today? No, ma'am. Okay, we'll get your notice to appear. Any additional matters for the record?
Nothing from the people.
Nothing further in this case, Your Honor.
Thank you. Okay, Kay, did you pay them the other one file? No. Yes. What's that? That counts it too.
Ali Diaz from 8:30, Your Honor, did we handle that?
He was not put on for the morning, he was only put on for the afternoon, and we will not be, I'm resetting everything at 1:30.
Heard that.
That's our morning docket, so Mr. Me, we should get ready for the jury trial.
It is. Thank you. And it is okay for me to call everyone for the afternoon. If I'm not here. Thanks very much.
Thank you.
Could Your Honor request maybe a 5 restroom break?
No, you have more than that.